All right, welcome. If you can hear the sound of my voice, raise your hand in the GoToWebinar. I can hear the sound of his voice, hand raising control panel. I see hands going up. Always makes me feel better. And why not? All right, seems like time to get started. So today we're going to talk about the residential listing agreement, how to fill it out, what to do with it, all of that sort of stuff. And I'm going to give you some practical tips as well as going through the actual contract, best practices, what can you do, how do you fill out certain sections to maximize your interest in that of your client. Now, the starting point, as you might notice, I'm beginning with RPR. And you might be wondering, well, why are you beginning with RPR? You're supposed to be telling us how to fill out the residential listing agreement, and that's in ZipForms. Well, if you're writing an offer to purchase a property, there's a program called MLS Connect, which allows you to take the MLS information and import it into your purchase agreement, into the all the contacts and that sort of stuff. Saves you time. If it's a listing, there's a good chance it's not in the MLS. Now, we're going to talk later about there are some instances when you might be writing the residential listing agreement on the property that's already in the MLS, but that's a different thing. We'll talk about that later. So what I always would do to start with is find the property in RPR. Now, I have a couple of these coming up, but I don't want to show you those addresses because I know what you guys are like. You'd be writing down the address and you go over and knock on their door and say, don't list your home with that guy. I'll do a better job. I know, right? I know. So what I'm going to do is demonstrate how to do this from a listing I already have, because there's, well, less chance of, what I mean. So let's assume, now this one is on the market. By the way, I'm looking to see how many of you have showed it. But this one is on the market, and but whether it is or isn't, the process is still the same. What you're going to see is an area here that says ZipForms transactions. So that's where we're going to start. So we find somebody says, I'd like to sell my house, come over and put it on the market. We look it up in RPR, which is a good thing to do anyhow. We then click on ZipForms transaction, and this is going to appear. And we're going to tip this. I would click on start a new ZipForm transaction. Now, if you'd already begun one, you could then go and get it and add it to it. But this is, well, way easier, and I like way easier. So we're going to click on that. And then it wants to know what kind of transaction. This is going to be a listing. So we're going to click on OK. And it's going to ask us about this one, and we're going to click on go to ZipForms. It may be confused because I already have one. This always pops up, just hit continue. Then we wait. And the reason we started in RPR is because we're lazy, time efficient. And you don't want to be typing the address of the property every time, the assessor's parcel number, and who the owner is. There's a bunch of information. So what's happened is that information has just been pulled in to my transaction. Not every scrap that I would like, but it's certainly better than starting from scratch. So now we've got the property details into our ZipForms. The next thing we would like to do is add a template. And what we would do is that would assume that you've created a template. Here, let me go back. Let me go back. Oh, I know, I shouldn't have done that. Don't go back in ZipForms. Let's just, that was not exactly what I wanted to do, but we're past that part. So in ZipForms, I just wanted to show you that hitting the back button is a disaster if you're in ZipForms. So now that we've imported the property information, what we're going to want to do is import two other things. One is our contact information for the client, and the other is all of our personal and professional stuff that we have in our template. So this is the one we just created. We're going to open it up, and now that it's up, what we were looking for, you see the button that says apply template. So we click on the template, and I've got a bunch of them. How about that one? And we click on apply. And what I've done in the template is I put in my information, the office information, my DRE number, the office DRE number, address, for all of that stuff that they're going to want typed in. I've already put it in, right? So I don't have to manually type that in. I've imported the property information. I've imported my information. And then the next thing would be parties. And that would involve clicking on parties, and we would go down. Now, it's probably already found the sellers because it imported it from RPR. And I would just want to make sure that their email addresses and things like that are there. Okay, so assuming we've done all that, oops, let's get to it, all right? Let's get to the good stuff. Knowing how to do this, and by the way, if you don't know how to connect RPR to ZipForms, I have a video on my YouTube channel. My YouTube channel is Upthink Real Estate. I'm expecting all of you to, subscribe. So we're going to go to Documents, and I've already, because I created a template, I have the basic group of documents. We're going to be doing the residential listing agreement. And notice it has my name, my information. It didn't do perfectly with the seller's name and information. That would need to be cleaned up. I'm not going to worry about that now. But this is agency disclosure. That's for another class. Fair housing and discrimination advisory. Read that, but we're not going to cover it today. The possible representation of more than one buyer or seller disclosure and consent. I'm not going to go through that today because this is about the residential listing agreement, wire fraud, and here we are. We have finally arrived. All right. And if we would have needed the import, as I said, from RPR isn't perfect. We would need to clean that up a little bit in order to make it the right names and things like that, but we're not going to worry about that right now. Date prepared. We're going to start at the beginning. Now, I've been asked many times, should that be the day that the listing agreement begins? And the answer is not necessarily. Date prepared just means the date you prepared it. So if I'm going tonight or even tomorrow to go see the seller or send it to the seller, I might prepare it today. And I know it bothers some agents that, you prepared it one day and then it's signed another day and dated another day, but that's nothing to trip about. It doesn't really matter. We need just put in today's date, or if it's going to be a couple of days, put in tomorrow's date. The reason for that is that date, and this is also true on the purchase agreement, identifies this residential listing agreement. Right? It identifies it as the one dated 12/03/2020. Notice that it has automatically filled out the APN number, the address of the property. It brought all of that information over from RPR. If the property is a manufactured home, and by the way, you may have seen that I've given you a sample, of one of these forms if you want to, print it out or follow along or log into your own ZipForms. I've also given you a PDF of the California Association of Realtors legal Q&A on this very subject. I was thinking that that's a waste of time because I know you guys have read all of the CAR legal Q&As, more than once or twice, but maybe somebody hasn't, so I thought I would include that. But we're just going to go through and fill this out. If this were a manufactured home, we would check the box. At one point, there was a separate listing agreement. But one of the things you'll notice about the California Association of Realtors, if you look at every version of their listing agreement, you'll see that they're about 90% the same, right? Even the commercial ones have a lot of the same words. So if it were, we would check the box, a manufactured home, and it would load an addendum. If it's a probate, conservatorship, or guardianship, and we click that box, it would then load an addendum. It used to be, in the old days, a completely different agreement. Listing price and terms. So what would be, we will start with just, let's say the price, 1.5. Now, other terms, that's this next box. Let me see if I can get back. Listing terms. Just because there's a empty box in a CAR form does not necessarily mean you have to type something in there. What kind of listing terms might we have? Well, there's a variety of things, but generally we don't want to write very much in here. Is it possible that we've negotiated with the seller that if we don't sell it for 1.5 in the first 60 days, as an example, or 30 days or 45 days, that the seller agrees to lower the price to 1.45, as just as an example, right? So we could be typing that in, because if the seller has agreed to a price reduction at a time, place in the future, it would be nice to put that in the listing agreement so we don't have to get another agreement signed by the seller in order to change it, right? That would be a common listing term. If the seller is willing to carry a loan, we might type that in, right? Now, it's not that big of a deal. Those of you that recently went through the real estate licensing process may recall that you were taught that if somebody makes an offer on the exact terms of the listing or any other price and terms the seller accepts, you've earned a commission. That is not really true in reality. So the idea would be if you wrote in enough terms, you could fill in enough of the blank so that you know that an offer would meet the exact terms of a listing. But by the way, that still doesn't get you a commission. You'll find if you read the MLS regulations that if you're representing a buyer, making a full price offer does not mean you've earned a commission. Right? It doesn't mean that. It has to be accepted by the seller. So we're going to leave that blank because we don't have, an automatic price reduction or something coming up. Then there's the magic words. The California Civil Code says in order to have an enforceable agreement to pay a real estate agent a commission, it has to be in writing. It has to have certain words that are specified in the Civil Code, and it has to be in no less than 10-point boldface type, right? And so there are the magic words. If these words, notice the amount or rate of real estate commission is not fixed by law, if those words are not in a form, then there's no enforceable agreement to pay a real estate agent a commission in California. I'm just saying. Now, there's other forms about commission agreements, which I talk about in other classes, but we're going to stick to this one. Paragraph A, we're getting to the really good stuff. The seller agrees to pay broker as compensation for services irrespective of agency relationships. Either, and we might want to say 6%, right? Why not? Worth it. And sometimes the buttons easy to push than others. Of the listing price, or if a purchase agreement is entered to of the purchase price, or you could type in a dollar amount, and you could add an explanation. So what agents sometimes ask me is that my commission or is it the gross commission? And the answer is it's the gross commission. Later, the form addresses how much of it are you going to give to somebody else, right? We'll talk about that. It could be that the seller says, look, I'm going to pay $50,000. That's it. I'm no 6%. You could write that in. What would be something that would go after the and? Well, I don't know if you've ever noticed on the, when you're looking at listings in the multiple listing service, and you see and by the way, if you have questions as I'm going along, just type them in. I may not get to them to the end, but feel free to type away. So have you ever seen when you're searching for available listings, active listings, that it'll say where it summarizes how much commission you're going to get? If you have a buyer, it'll say dual/variable, right? Well, what is a dual/variable commission rate? Well, what that would mean is, let's say I told the seller that if I find the buyer myself for your property, I'm only going to charge you 4.5, or something else, right? Because sometimes the seller will say, well, if you find the buyer, are you going to still charge me 6%? Now, by the way, my answer would be yes. But let's say we've negotiated that if we double in the transaction, that it'll be 5%, 4.5%, or something else. That's a place where we could write it in, right? And then when we put it into the MLS, we're supposed to tell the other agents that this is a dual or variable commission. And by the way, I get asked this question a lot, is it, if I see that in the MLS and I represent a buyer, does the listing agent have to explain to me what this dual variable thing is? And the answer is no. The listing agent has no obligation to tell you how much their gross commission is, right? They'll tell you how much they're giving you, but they don't have to tell you how much they're getting. And by the way, just because they're the listing agent doesn't mean they have to get the same amount as you or less than you. It could be more, and they don't have to tell you. So I have a question. Is there a difference between dual and variable? The answer is not really. It means the same thing here. It varies, and there's more than one commission amount. There's another question about a for sale by owner would like my commission amount tied to the purchase price. If I list it under, I get 2%, 2.5. That would be the best way to do that. You could write that in the and section, right? That you get paid more if it's, and by the way, I would always tell the seller that I'm always paid a percentage of the price. If the price goes down, I get paid less, right? I get paid less. But I understand where they're going. If money works, then I'll pay you more if you give me a higher price. Yeah, they're not having, I understand, I know what they're like, right? But anyhow, you could write that in after the and, right? Most of the time there's nothing written in, but if something weird is going on, like you don't get as much if you double end it, or you get more if it's above, then that would be a place to put it in. Thoughts on offering a higher commission if sold over, I don't generally get into that. What the problem with discussing with the seller, if I get you over a certain price, I want more money. The only weirdness about that is you're kind of sort of saying, I'm not going to try as hard, right, to get you this price. I'm only going to try. I mean, you're basically saying that maybe your services would vary, but whatever you want to negotiate, you can do it. You put it in here. No one's going to see this but you and your broker. The other agent won't see it. Escrow does not see the listing agreement, right? You understand? Escrow does not see the listing agreement, right? There's just a commission demand and the seller has to agree to it. But anyhow, that was all. I don't get that much feedback on that one little box. Paragraph 3A1. This is the good stuff, right? What do you need to do under the residential listing agreement to have earned a commission? And the answer is there's about 6 or 7 things that would allow you to earn a commission. Let's go through the list. It says if during the listing period or any extension broker, that's one way. If the broker finds a buyer and consummates a deal, you've earned a commission. 2, a cooperating broker finds a buyer, consummates the deal, you've earned a commission. 3, the seller finds a buyer, consummates the deal, you've earned a commission. 4, or any other person procures a ready, willing, and able buyer whose offer to purchase the property on any price and terms is accepted by the seller, provided the buyer completes the transaction or is prevented from doing so by seller. Broker is entitled to compensation whether any escrow resulting from such offer closes during the period. So those are already 4 ways for you to get paid, but there's more. What if, because those first 4 all deal with if during the listing period any of that happens, you've earned a commission. The second, or 2, is what is referred to as the safety clause or the protection clause. And I usually, let's say the listing is going to be 90 days. I would put in 60 days, 90 days. I've been doing this for a really long time. and I don't recall anybody collecting on the safety clause, but what do I know? So what the safety clause says, let's say I have a 90-day listing and it's day 88, day 89. And I'm talking to a buyer about the property, and the buyer's like, we're really interested. We think we'd like to buy it, but we want to spend a couple of days to think about it, to pray about it, meditate about it. Well, you see, the problem is that if those buyers take 2 days to decide, and my listing is already about to expire, what's going to happen is they're going to drive by the house, let's say on Monday, and they'll notice that my for sale sign is no longer in the front yard. And then they're going to go knock on the door, and when the owner answers the door, they're going to say, hey, what happened? We wanted to buy your house last week. We talked to your agent, and now the sign's gone. And the owner says, well, yeah, the listing is expired. And the buyers say, well, do you still want to sell? And the seller says, yeah, come on in. I don't have to pay the agent a commission now. There's a little bit more flexibility in price. I'm not sure what that message was, Anna, but anyhow. So what this clause says, the safety clause, is that if I give you a list, you being the seller, of any people that I have negotiated with during the term of this listing, and if they buy the property within 90 days after the termination of this listing, I still get paid. That, by the way, is 5 ways for you to get paid. 4 is if the property is sold by anyone, and it goes through the list of anyone, during the listing term. 5, if it's sold to one of the people on your list within the whatever you write in for the protection period. And it says, unless otherwise agreed, sell after cancellation enters into a contract to anyone that or person who physically entered and was shown the property during the listing period, or any extension by broker or cooperating broker, or for whom broker or any cooperating broker submitted to seller signed written offer to purchase, right? If you've shown the property or written an offer on the property, you can put their names down here, and if they eventually, soon you'll be able to put their names down. Not, I mean, right here there isn't a place, but there is one coming up. And if those people buy it, you get paid a commission. That's 5 ways. But we're not done. There's still more. There's more ways to earn money under this agreement. Yeah, because look at paragraph 3. If without broker's prior written consent, the property is, this would be number 6, withdrawn from sale. 7, conveyed. 8, leased. 9, rented. 10, or otherwise transferred or made unmarketable by a voluntary act of seller during the listing period or any extension of any extension. So unless you've put into your listing agreement what is sometimes referred to as a weasel clause or a cancellation clause, which basically says if the seller decides, so this is how I would explain it to people. I would say, because I used to have like a little flyer and I would attach it, right? What I would say is under the current listing agreement that most real estate agents use, once you've signed it, you're locked in. You don't have the right to fire them, even if they're not doing a really good job, because it says in the listing agreement that if you withdraw the property from sale, like if you tell your agent, I'm not letting you show it anymore, I've changed my mind, I don't like you, I don't want you to be my agent, that if you attempt to cancel the agreement, you owe the whole commission. I'll show you where it says that in the listing agreement. Right? That's what it says in that paragraph. If without broker's prior written consent, the property is withdrawn from sale, conveyed, leased, rented, or otherwise transferred or made unmarketable, the whole commission, 6%. That's what it says. But you could say, hey, if you don't like me, that's fine. You just give me, 1 week's notice and I'll let you cancel, right? I'm just saying the right to cancel does not exist in this contract unless the broker and agent have totally dropped the ball, right? Which not even tried to sell the house. If completion of the sale is prevented by a party to the transaction other than seller, then compensation which otherwise would have been earned shall be payable only if seller collects damages in suit arbitration, and then you get half. All right. So what this is saying, that paragraph 3B, is that if, let's say, you're in contract and the buyer backs out, right? The buyer's lost their job and the buyer doesn't have any contingencies and the buyer made a 3% deposit and the seller is keeping the 3% deposit because the buyer backed out without removing, after they've removed all their contingencies. What this says is the broker gets half, right? That's what it says. The broker would get half. It says here, and then in an amount equal to 1/2 of the damages recovered or the above compensation, right? Well, which means obviously usually 1/2 of the deposit is a lot less than the 6%. How would you normally respond to the seller's request to cancel a listing? I just hang up and then block their phone number, and well, how do you respond to a seller's request if you've been doing a good job marketing the property, communicating the property? Then it wouldn't necessarily be, it's painful. But what I would say to people is if they have a legitimate reason for canceling, right? And there's some reasons for canceling that are not really legitimate. I'll give you an example. Let's say a neighbor comes and knocks on your listing's door, and the guy says, "Hey, why didn't you tell me you were thinking of selling your house? I would have bought it. We wouldn't have needed to get an agent involved." And the seller says, "Wow, gee, I wish I had known. I never would have listed it with the agent if I had known that." And so the friend says, "Look, just tell your agent you've changed your mind, right? Just tell them you've changed your mind and you've decided not to sell it. Cancel the listing, sell it to me. We'll split the commission amount difference. We'll both be ahead." So sometimes what I've done is, because they're not going to tell you that, right? Well, I found a buyer that I can circumvent you and sell it to them and not pay a commission. So that's why I want to cancel. That's not what they say. What they say is, "I've decided not to sell my house. I've decided to stay here. I don't want to move. I'm going to keep it forever." And so in the cancellation form I would give them, I would write in a proviso that says that if they sell the property within 1 year, they agree to use me as their listing agent or pay me this commission. This, by the way, smokes them out right away. Because some of them start going, oh no, I'm going to sign that. Well, why not? Well, I want to have options. Well, what do you mean? You just said you don't want to sell your home anymore. Well, I don't know. I just want to have options. All right. And then, by the way, I stared down sellers and said, no, you can't cancel. And then they would send me an email saying, I don't want you to show it anymore. I want you to take down your sign. And then I would make a screenshot of that paragraph about being withdrawn from sale and tell them you're 6%, And then at that point, they usually become more cooperative. So you have to understand, sometimes there's a good reason why they don't want to sell their home. Other times they're just trying to rip you off, and you need to sort of figure that out. In addition, seller agrees to pay broker. You necessarily don't need to write something in here. We used to have certain kinds of transaction fees or transaction coordination fees and other weird things that you could write in. I would generally leave that alone. All right. Then paragraph D. This requires a little bit of thought, because what paragraph D is getting at is that this property is probably going to go into the multiple listing service, right? Probably. And it says that broker is authorized to cooperate with and compensate brokers participating through the multiple listing service by offering them compensation specified in 3A, either or. Now, there's two thoughts about this. One thought is, if I leave it blank and I don't actually talk to the seller about how we're going to split the commission, then when I put it into the multiple listing service, I can kind of put in whatever I want. However, if the seller has spoken to me about, I want the agent who finds the buyer to get this much at least, then you could write it in, right? And so this would be transparent. I'm going to give 2.5, 2, 3, whatever. to the agent who finds the buyer, or a flat fee amount. I, by the way, usually give the seller a copy of the full agent printout for their own listing. And I've had agents say, you can't do it. It's not for clients. It's their listing. There's no private information in their listing, just to show them what I put in the MLS. Sometimes they do not care. They don't want to know. They don't want to talk about it. It's 6%. If you leave that blank, then you could structure it maybe a little more flexibly than if you wrote it in, but you should reflect whatever it is you've agreed to do with the seller, assuming you agreed. Seller hereby irrevocably assigns the broker the above compensation from seller funds through escrow. That's what it says. The seller still is going to have to sign escrow forms. Paragraph F. This is one of the more interesting paragraphs. First of all, there's F1. F1 says, have you, if you're the seller, previously entered into a listing agreement with another broker? And if so, tell us something about it. This would come up in one of two situations. One is that broker safety clause. So let's say, and both of the situations have to do with expired listings or something like that. So let's say the seller has the property listed already, and when it hit the end of its term, the previous listing agent actually gave the seller a list of names of people that they've negotiated with. And that says if those people buy the property, they get a commission. So you can write in here that it was previously listed this date to that date. And then you could write in here, the next paragraph, F2, the names of the people if the seller gave you, if the seller had a list of names of people that were given by the previous agent with whom they've negotiated. The other time that I've used F1 is about to expire listings. So this is the question. There's a property on the market. Let me just see what this is. What is the proper way to document list of names negotiated with? You have to send an email, or is it enough to keep them all in a shared spreadsheet? It says in the contract that a written list. That's what it says. So I use tracking software on my email. I would prefer to send them a written list in an email that was tracked so that I knew that they and could prove that they got it. Right? You could also mail it to them. Right, you could do. By the way, I have been doing this. I've been a broker since, and in all those years, I've never known anybody to collect on the safety clause thing. Right, I'm just saying. I'm sure it's happened, but not in my experience. So when's the other time we might use this? So this, let's say you're an agent who farms in a particular area, or you're just known in a particular area, and you get a phone call. And the person that calls you says, look, my home is already on the market right now. Maybe you know, maybe you don't, this is the address. My listing is expiring at the end of December, right? The way it's going, I don't think my agent is going to sell anything. They've dropped the ball. I have no intention of renewing the listing with them. I'd like you to come over and talk to me about putting my home on the market once I'm done with this guy. So the question is, can you do that? Is it legal? Is it ethical? Is it moral? Is it not criminal for you to go and talk to that seller and answer questions about listing it in the future? And the answer is yes, that's okay. What do I have to prove that? Well, I know that all of you guys have the National Association of Realtors Code of Ethics, right? The app on your phone, right? Or, if you're old school, you carry like a pocket copy with you, right? And whenever you have a few minutes, you flip through and read, right? I'm sure that's what you guys do. Well, when you're doing that, you would want to look at Standard of Practice 16.5 and 16.6. And what they say is that 16.4, it says realtors shall not solicit a listing which is currently listed exclusively with another broker. But then it goes on to say, if you ask the other broker, like you see a for sale sign and you don't know when it expires, and they won't tell you when it expires, you have the right to actually go ask the owner, when does your current listing expire, right? But it should be on the MLS. Then it says that the realtor shall not solicit if somebody's already under an agreement. But it says 16.7, the fact that a prospect has retained a realtor as an exclusive representative or exclusive broker does not preclude realtors from seeking such prospects' future business. The fact that an exclusive agreement has been entered into with a realtor shall not preclude or inhibit any other realtor from entering into a similar agreement after the expiration of the prior agreement. So what that means is it's a violation of MLS rules and the association and the code of ethics. If you say to the current owner, look, why don't you just call them up and say you want to cancel, right? I don't want to wait till January. I don't want to lose any time. Just call them up and tell them you don't want to sell your house anymore and get them to cancel your listing, and then I'll list it next week. You could be in trouble. And I'm just saying, this is all something you need to do carefully, because what happens if you end up at a hearing for an ethics violation, they can kick you out of the board of realtors, out of the union, right? They throw you out of the union, you lose your access to the MLS. It's not a good thing. Could that encourage a seller to wait for a new contract? I don't know what that means. What if you say, I'm not taking, but if you do, but if you do that, you need to be very careful about this. So if you say, well, I'm not telling you, wink, wink, to cancel your current listing, but if you did, I'm ready to go. You need to be very careful, because they'll turn you in. You would turn them in if you were the agent on the other side. Yes, you may offer a lower rate, but the point is that this is something you need to be very careful about. So while they're in the listing agreement, you are not to tell them that they should cancel. That is a clear violation of the code of ethics. But you can say, all right, your current listing expires on December 19th. We'll start the next day. And I would write in, because sometimes I've heard this, they'll say, well, okay, yeah, I don't think my agent's going to do anything by the end of December. They certainly haven't done anything for the last 3 months. I doubt that they're going to get any better at this. But what if, right? You're asking me to sign this agreement with you right now, but what if, miracle of miracles, that agent pulls one out of the hat, finds a buyer, and what happens? Well, you can write in there that basically it's saying that if it sells let's look at 3. If the property is sold to anyone listed above during the time seller is obligated to compensate another broker. Broker is not entitled to compensation under this agreement. So if it sells before their listing expires, this isn't any good, right? Because it's already sold. And then I'm just saying that's what that means. But yes, I just wanted you to know it's legal, ethical for you to go talk to a seller about selling a property after the listing is expired. And by the way, what you would do is up here where it talks about beginning date. So if they say, well, my listing expires on the 19th, I'd say, great, we'll start on the 20th, right? And then add, 6 months or something or more, why not? And so we would start it the next day after their current listing expires, so we don't get into trouble. Items included and excluded in the sale. Well, this is nice to talk to them about, right? However, the purchase contract says that what you put in the listing is not important. What's important is what you put in the purchase contract. Will the buyer get that green concrete bench that's in the garden? Who knows, right? By the way, that's not something that's on the list on the purchase agreement. You might ask them, is that staying, is that going? It gives you a way of going through the property and having the discussion, and you could write in things that are included that would make it sell better. You get to keep the big screen on the wall, you get to keep the patio furniture, you get to keep the green bench in the, you know, in the garden, and you don't get, we could list the things they're not going to get. You don't get the chandelier in the dining room, you don't get, you know, the original Monet on the wall, whatever. But you just need to know that and this is what it says here, that the purchase agreement supersedes any intention expressed above, right? You see that the purchase agreement is the one that's going to control what they get. Didn't get to seller listing details. So I think what I'm being asked is, you tried to look somebody up and you couldn't find them in RPR. That doesn't mean it's not listed. RPR is not perfect, right? You'd want to search for the property within the MLS where the property is located. I'm not going to spend much more time. That's a longer answer, how to hunt them down. But look in the MLS. RPR is not perfect. I've seen cases where RPR didn't know that it had been in the MLS, but when you search the MLS, it was there, right? You just need to look. So I think what I'm being asked is, what if you didn't know that it was listed until after you talked to them because they didn't tell you? You know, it's just don't, you know, now that I know, I'm reporting you to the Board of Realtors. I just don't tell, you know, I mean, it's not a big deal. You didn't, what the code is about is you knowingly, purposely, deliberately interfering with people. For example, if you send out a mailing to everybody in a particular neighborhood and it happened to land on people whose homes were already listed, that's not a violation of the non-solicitation rules. And by the way, putting in this is not intended as a solicitation of another broker's listing, why not? But it doesn't really matter one way or the other. If you're not targeting active listings, it's not a violation. And if you are targeting active listings, it's a violation whether you put that clause in or not, right? So it's possible that someone's going to call you up and talk to you without saying, hey, it's on the, you know, MLS right now. Usually RPR knows, which is why I start there. You would want to know from the seller if there's any leased or liened items. If you see solar panels, you should ask them about the solar panels. Do you own them? Do you lease them? Did you get a peace loan? Is there a loan on them? Because you're going to see in the purchase agreement, paragraph 8B, it says that the acceptance and the ability to take over any of those leases and liens is a contingency of the agreement, and you have to get a copy of those to give to the buyer in order to remove that. So any leased items, any liened items that are on the property, and notice it says that right here, seller will provide the buyer as part of the sales agreement copies of these documents. So we might as well, you know, get busy and get them now. You want to know, right? You want to know. The multiple listing service, what is it? Why do we have it? What's in it? Well, this is sort of just an explanation of how the MLS works. Now, what information is provided? Just about everything. What is the broker's MLS? So I'm in MLS listings territory, right? So I could click that. Now, let's say the property is actually in Hayward, right? Alameda County. That would not be the primary MLS for the geographic area. Is that a big deal? It could be, but it doesn't have to be. Now, the reason it could be is, let's say I have a listing and it's in Sacramento, right? I'm not a member of MetroList, but in MLS Matrix, in Bay East, in the Matrix, in our Bridge or Matrix MLSs, I can add a listing in Sacramento. I can type it in, I can pick Sacramento, I can hit submit, it'll give me an MLS number. In 15 minutes, it's on Redfin. And then the next day, it's on Zillow, Miller time, right? I listed a property in Sacramento. Now, the problem with that is that an agent in Sacramento is not going to see the listing if they're just searching MetroList because you didn't put it in MetroList. Now, could that be a disadvantage to your client in Sacramento that it's not in the basic MLS for that area? That could be a problem because a lot of lazy agents aren't going to search beyond their MLS to see if this property is for sale, and they're going to miss yours. So what you would do is you would do what's called a reciprocal listing in MetroList, which you can do. You have to log in to the MetroList software from the MLS and add the listing there. You add it twice. Right? You add it in our MLS, but you add it in their MLS. But you're supposed to tell them whether or not your MLS is their MLS. And you could explain it's not really, because we have a reciprocal arrangement, it's going to be in both MLSs, it'll be wonderful, don't worry about it. But you need to know that that's an issue. If the property is not located in your prime MLS, unless you do a reciprocal listing in that MLS, it won't show up in MLS searches in that MLS, right? Which means less people will know about it. So then this box is part of the CAR, NAR, MLS. We want you to use the MLS. And so this basically is saying you should use the MLS. It's going to produce more buyers than if it doesn't go in the MLS, and the seller should know that. What they want you to do is to convince the seller that putting it in the MLS is really good for them. I'm not going to go through all of that, but that's what it says. And notice they want them to initial it. Clear cooperation. What does clear cooperation mean? Well, in our MLS, in fact, in virtually every MLS that I know of, they require clear cooperation. Now, what that basically is saying is you can't have pocket listings if we're talking about residential properties, right? 1 to 4 units can't have pocket listings. If you're a member of the MLS and you list a property, you're not supposed to have a pocket listing. Pocket listing means you don't put it in the MLS. Now, the only exceptions to that, and there's 2 of them in the paragraph, is that if it's only being marketed within a brokerage, that means it can't be marketed to the public. Marketed to the public means for sale sign in front of the property. It means putting it on the internet. It means making flyers, any of that sort of stuff that the public would have access to. If you do any of that, it's supposed to be in the MLS. The only other exception is, as it says here, 1-to-1 promotion between licensees and their clients, right? What does that mean, right? Well, I've spoken to the legal department of the California Association of Realtors, and I've spoken to compliance at the MLS, and nobody really knows what it means, right? Does a client mean somebody I have a buyer representation agreement with? Does it mean somebody I've worked with in the past? Does it mean somebody I'm hoping to work with in the future? What is a one-on-one promotion? Do I have to be in front of them with my mask 6 feet away? Could I do it by email or text or that sort of thing? By the way, if you have pocket listings, what you can do is advertise that you've got pocket listings. The clear cooperation is about advertising a listing. So if you just write an ad and say, hey, I got some listings that are on the MLS, if you're interested, to find out, call me, right? That is perhaps not a violation of this rule, because according to the MLS compliance, you're not marketing a particular listing, and you're not marketing a particular listing. Do they sign the MLS box to indicate they understand only if they want the listing on the MLS? What this is saying is they have to put the listing on the MLS. MLS rules require that residential real property with 1 to 4 units and vacant lot listings be submitted to the MLS within 1 business day of public marketing. It is no longer an option. Now, I do commercial real estate, by the way, which is a different world. Right? We don't usually put things in the MLS. It's totally different. But what the new policy says, that if you are going to put a sign on it in the property, if you're going to put it on the internet, if you're going to have a landing page, if you're going to market it in any way, it has to go into the MLS. There isn't a way for the seller to opt out. What did those attorneys say if a pocket listing is marketing with property information but no address publicly shared? What the attorneys are saying is we don't really know, because the enforcement of this is up to your local board and your MLS. So if one of your friendly other real estate agents turn you in, and by the way, that's almost always what happens. Somebody else, one of your buddies turns you in, right? Or not your buddy. And so now they may have a hearing about it, and you're going to have to convince them you didn't violate the policy. And how the different boards handle this varies somewhat. And so you're rolling the dice as to whether or not, and they'll fine you and do all sorts of things if you don't put it in the MLS. So let me just, I got a few more minutes. I haven't seen evidence that this is happening, but one of the things that could happen is that, let's say I have a seller who says, I don't want to put it in the MLS because I don't want to pay another agent a commission. I'm willing to pay you a commission, but I don't want to pay the buyer. Why do I have to pay the buyer's agent a commission? I don't want to do it. Now, you do understand that in addition to putting it on the MLS means it might get more exposure, it also means that there's going to be an obligation to pay a commission, which is what I think a lot of people in NAR were voting for. Because what they weren't happy with is listing agents pocketing the listing, not putting it in the MLS, selling it themselves, and not giving the other agents a shot at it. But what I could do if the seller says, I don't want to pay another agent a commission, and by the way, if they say, I don't even care if it's in the MLS, I got a problem because it says I have to put it in the MLS, but it doesn't say how much commission I have to pay to the agent who has a buyer. It doesn't say I could put in $1, I could put in $10, I could put in $1,000, I could put in $500. It doesn't say, and they can't regulate that because of antitrust laws. Now, your broker may have a policy against you doing something like that. You won't be making as many friends in the real estate industry. And by the way, if you have a buyer representation agreement, I'm closing on a transaction right now where we have a buyer representation agreement that says 3%, but we're only getting 2%. The buyer is making up the 1% difference, right? I'm just saying that having a buyer representation agreement gives you a little bit more leverage, but I think that you may see some agents, since they can't double in it, just aren't going to pay much to an agent who finds a buyer. Coming soon, it still has to go into the MLS as a coming soon, right? You have to go and put it in. If you don't do it within 1 business day, they're on you. Now, it will say here, seller instructs broker to SELM, which is the seller election, to sort of exclude from the MLS. And the first one would say, let's say the seller says, well, I don't want people showing it right away, right? Because it's not clean, it's not staged, we don't have pictures. So we would make that a coming soon. And in here we would say, and there's another form for this, we're going to start on a particular date, right? We're in 2 weeks and 3 weeks, and we would use that other form. The paragraph 2 says, seller instructs broker not to market the property to the public. Look at what it then says. Seller understands that no public marketing will occur, and the scope of marketing that will occur will consist only of direct one-on-one promotion between the brokers and licensees affiliated with the listing broker and their respective clients. That same language again. So the seller could opt out, but no for sale sign, no single party property website, no digital marketing, no Facebook ads, and you just don't get any of that. So I'm just saying that's what happens if they mark that. So we usually are doing something in D1 because if tonight is the listing appointment, it is unlikely they want it to be shown tomorrow, right? So there's a time period before we put it on the MLS. Seller understands and agrees that should any public marketing of the property occur, the property listing will be submitted to the MLS within 1 business day. See, they're really serious about this. Now, the clear cooperation policy does not apply. I don't know where that is. If it's a 1 to 4 unit residential property in any of the MLSs around the Bay Area, it applies. Right? You have to go to something not 1 to 4. MLS data on the internet. They should know that their address is going to be on the internet and pictures are going to be on the internet. They should know, can they opt out? Yeah, but then people on Zillow and Redfin and Realtor.com aren't going to spend much time looking at it, right? Because they kind of want to know. They want to see where it is on a map and all that. They also should know that different sites are going to come up with an estimate of value. Now, people say, well, if the seller checks this box, does that mean that Zillow and Redfin and Realtor.com are not going to do automated valuation models? And the answer is no, they're going to do it anyhow. It just means that the CAR, there's one way in which it isn't being done through the CAR, but Zillow is going to have the price, Redfin will have a price, everybody else will have. Seller representations, how am I doing? Seller represents that otherwise specified in writing. They're going to tell you, are there any lawsuits, any litigation, any arbitration? Are you in bankruptcy? Do you know if there's a notice of default? That's all up in that paragraph. Broker and seller's duties. Let me ask you this. You're the listing agent, and you've just filled out this form. Straight, didn't write in a bunch of weird stuff. And I'm an agent representing a buyer, and I call you up and I say, have you gotten any offers yet? And you've gotten 2, right, let's say, and you say, well, yeah, I gotten a couple of offers. Great. Tell me what the highest offer is. Can tell me how much the offers are. Now, my question for you guys is it okay for the listing agent to tell other agents how many offers have been received and what the amounts are? Is that ethical? Is it legal? Is it moral? I've had agents say, I can't tell you that. I can't tell you that. Why would you ask me that? You know I can't tell you that. It's illegal. It's unethical. It's immoral for me to tell anybody how many offers I've gotten and what the amounts are. And I'm like, well, really? Well, let's look at this paragraph. It says the broker agrees to use reasonable efforts and due diligence to achieve the purpose of the above. Broker is authorized, but not required to order reports and disclosures to advertise and market the property, including the MLS and the internet to the extent permitted. And then look at this. Disclose to any real estate licensee making an inquiry the receipt of any offers on the property and the offering price of such offers. That's what it says. So the standard residential listing agreement gives the listing agent the authority to talk about the offers. And in that possible representation of more than one buyer or seller, there's actually this clause, which appears also in the purchase contract, that says your offer may not be confidential, that they could tell other people about it. It is not illegal. It is not immoral. And somebody is telling me that Redfin has some homes where the seller's chosen not to have a Redfin estimate. That may be true, but I'll bet Zillow does. I don't know. I have a feeling you can't avoid the internet. So the point I wanted to make is that the standard residential listing agreement authorizes you to tell people about that. Yes. Okay. Thank you. What else do we have here that's important? The broker agrees to present all offers. Seller agrees to consider them in good faith, making the property available for showing, inquiries of interest, determining at what price to list and sell the property. That's so if it's underpriced or overpriced, it's not your fault. Now, investigations, if you're going to be selling a property, it's very good to get a termite report. It's good to get a property inspection. And they should start getting the homeowner association documents. And there may be other things that you might want. They may want a foundation inspection, a pool inspection, a spa inspection, electrical inspection. There may be other reports. Natural hazard disclosure is contained someplace else, but there's other reports. So by checking these boxes, the seller is authorizing the agent to go and arrange for all the inspections and reports, which is something that you ought to do because it makes it a lot easier to sell a house if you've got all that stuff. Paragraph E is called the hold harmless clause. And basically it says that if the seller lies to us, about the condition of the property or parts about the property, and there's a lawsuit because the seller lied to us, that the seller agrees to indemnify us. Indemnify, defend, and hold a broker harmless from any claims, disputes, litigation, judgments from information they did not give us or information that was wrong. Then there's agency relationship. The listing agreement, boiled down, does two things, right? One, creates an obligation of the seller to pay a commission. That's what we've been talking about. But number two, the listing agreement also creates an agency relationship between the seller and the listing office. And it's possible to be a dual agent, but you can't just be an agent of the buyer if you have a listing. So if you have a flipper and you're representing the flip guy in buying a property and it's not on the MLS and you use a listing agreement so you can sell it to your hand-picked buyer, you're violating the agency part of the listing agreement. You need to use a different form. By the way, I have a video on that also on my YouTube channel. And then the rest of this is about confirming. There could be competing sellers and buyers. So the way this, I was farming intensively an area and I would get a listing and then another seller of the same model would want to put their home on the market for less than the one I just listed. And they would want me to do it. Can you understand how some sellers got, kind of miffed that I was competing against their listing? So this is in the possible representation of more than one buyer and seller, but the idea is it's not my fault if your neighbor wants to put the home on the market for less than yours. And whether they do it through me or somebody else in my office, I'm just telling you, we have no control over that, right? You're going to just have to respond. If I don't do it, somebody else will. I'm just saying that's in the contract. So security, audio, and video. By the way, you ought to find out if the seller does the seller have a security system? Is the seller listening? Is the seller watching? You should ask. By the way, when I show property, I tell the buyer, you should assume that the seller is listening and watching while we're going through the listing. I'm just saying, if you don't want to put on those little booties they give you, you should know the listing agent or seller may be watching you not do it. I'm just saying, right? And you want to make sure that they should put away valuables, that they should have insurance, right? All that stuff. They should know that their property is going to go on the MLS and the photos is going to go on the internet. Now I get asked a lot. So the buyer buys the property and then the buyer wants to remove the photo. So the buyer says to the agent, say to me, well, how does my buyer get all the photos off the internet? I'm like, do you realize what you're asking? How to get something removed from the internet? Go ahead, write Zillow and Realtor.com and write Redfin and Homes.com and the other 500 websites where the listing and the pictures reside. They're not going to take them off of the MLS. Now, usually the seller doesn't care, but they're leaving, but the seller just needs to know that photographs of their house are going to be on the internet, right? Which usually they understand and want. Is there going to be a lockbox on the property, right? It's good to have one. You don't want to have to be driving there, just open the door. You can require a special code so people can't just go in whenever they want to, call before showing, a CBS code. You can do stuff like that, but you would need to explain to them what's going on. I usually would not only put on a regular Supra box, but also a combo box just in case somebody else needed to get in and I could give them the combination. Is there going to be a for sale sign? Additional terms. We're not going to be checking any of these boxes right now, but then there's management approval. Your broker will probably approve it. If not, talk to me. You need a new broker. Dispute resolution, mediation, and arbitration. If you want to explain this, I usually tell people, I've never had this come up really with a listing. Most of the time where there's mediation and arbitration, it involves buyers and backing out of contracts and that sort of thing. Rarely does it involve listings, but the difference between the two is mediation is like, marriage counseling. And you can go to the marriage counselor and they can tell you what you should and shouldn't do, but you can keep doing what you've been doing. Arbitration is more like, divorce court, and that's something that is binding. Do I have a simplistic understanding? So I was asking about the possible representation of more than one buyer and seller. The buyer side, yeah, partly the buyer side for the possible representation. There was a Coldwell Banker got sued, and they're a big brokerage, so they get sued a lot. And why they'd gotten sued is that a Coldwell Banker agent was representing a buyer bidding on a property. And the Coldwell Banker, I think another branch was the listing office, and another Coldwell Banker agent sold it. And so the buyer is saying, wait a second, Coldwell Banker, right? Because you understand, who is the agent in the transaction? And the answer, it's the broker, not the salesperson. So what the buyer said in their litigation is Coldwell Banker is my agent, and they shouldn't be representing other people competing for the same property I want, because the other buyers, also represented by Coldwell Banker, kept bidding up the price. And the guy sued, right? So what for a buyer, you would say, you need to understand that and many brokers don't want you representing more than one buyer, but talk to me if your broker won't let you do that. But either I or other agents, this is more likely to be sellable, other agents in my company may have a buyer also bidding on this property, right? Which I don't necessarily know anything about or have any control over. But just so you understand, that would mean we in the royal sense of the word, we, right? EXP has 5,000 agents in California. It's one broker. Is it possible that another EXP agent is representing a buyer on the same transaction? You just need to understand that's possible, and there's nothing I can do about it. I wouldn't necessarily represent two buyers offering on the same price, because I don't know how to get around the conflict of interest. I know what the other offer is, and of course my clients would want to hear. I'll have a friend do it. This is the entire agreement. Paragraph 24 is simply asking them, do you have the authority to sign this agreement? Right? Do you? Now, I talk about in my investor class about how to make this like a preemptive, a future one where they don't even own it yet. Usually we don't write anything in here, but you'd want to know, you should have looked to see who does RPR and who does Realist say owns the property, and see if it matches the people that you're talking to. But you would ask them, is the property in a trust? Is it held by an LLC? If so, if that's who you're signing on behalf of, that's representative capacity. You would check the box, go ahead, fill it out, sign it. And we've done that. I'm not going to go through the seller advisory, but it's a good thing to go through. It talks about ordering inspections and reports. It talks about disclosures, but my recommendation is you get them to sign this and then get out of there if you're doing it, in person or virtually. And then you want to send them, after they've signed the listing agreement, the TDS and the SPQ, right? And I use the Glide program to do that, to get them to fill it out. And then after they've done, those require thought. You want them to start filling out all the other boilerplate disclosures, market conditions advisory, statewide buyer and seller advisory, all that stuff, and start getting it together afterwards. Well, I've gone on a little bit long. I know that's probably, bothers a lot of you, but I went on a little bit long. I may do more classes about some of the other forms and things like that this is referring to, but that's the basic how to fill out the residential listing agreement. I hope you found that somewhat helpful. And if not, well, my feelings are hurt. That's really all I can say. I'm going to be having a special seminar coming up in a couple of weeks for people that want to take their business to a higher level. I've got a great lineup of speakers, some top people, the top people, right? You'll be impressed. We'll make sure that everybody that attended today gets a special invitation for that. And have a good day. Stay safe out there, everybody. And I'll see you again. Bye.